Phony federal papers are filed by Turtleboy's opponents in the most recent Bederow letter, which we're going to take a look at, even though it's, by the way, been removed from the Massachusetts State Court docket. And we're going to take a look at the special prosecutor Hank Brennan's $566,000 bill. Hard to know where to start when there's just so much happening, even though it's summer when things usually slow down. I'm attorney Andrew Myers, and this is About the Law. Mark Bederow has written a number of very articulate letters in the Aiden Kearney case, and we're going to take a look at the most recent one, which was sent to the prosecutor of Aiden Kearney in the case against him in the Norfolk County Superior Court. Even though Karen Reed has now been found not guilty of all three major charges against her, the Aiden Kearney case is still going. You know, Mark Bederow, he has been a guest on this program. It's summer. He's taken some time off. That's, no problem at all. But this is his letter of July 12th to Robert Cosgrove, Special Assistant District Attorney, Norfolk County District Attorney's Office in Canton. Dear Mr. Cosgrove, I just got to make sure everybody can see this letter. I write to bring to your attention several concerns we have with the July 7th, 2025 discovery production with the hope that you will resolve them prior to our August 13th appearance. Yeah, there's a status conference in the case on August 13th, and the problem is or the reason for it all is to update and do a status check on what is going on with the discovery. And Mark Bederow, the attorney for Aiden Kearney, is saying there's some serious problems here. What previously appeared obvious is now undeniable. The investigations that led to Aiden Kearney's indictments were essentially outsourced by the Commonwealth to Catherine Peter, a private citizen who, motivated by her obsessive hatred for Mr. Kearney, inserted herself into this matter, and whose checkered past includes filing forged legal documents to gain an advantage in a petty dispute with him. Kenneth Mello and the Massachusetts State Police ignored numerous red flags that every seasoned prosecutor and experienced detective should have recognized. An uninvolved civilian facing her own criminal charges with personal animus against the target of an investigation and a history of forgery pestered authorities by inserting herself into an official investigation by providing edited materials without a sufficient chain of custody or demonstrating the reliability of the evidence. They similarly ignored overwhelming evidence that Ms. Peter assisted, redacted, was the architect of a plan to make a witness, which she knew would lead Mr. Mello to charge Mr. Kearney with witness intimidation. See demand letters of September 12th, October 8th, and we've gone over those before on this channel. Rather than vet Ms. Peters' dubious credibility and tread cautiously, Mr. Mello and the MSP consciously ignored Ms. Peters' clear motive to falsely accuse Mr. Kearney and her demonstrated history of doctoring evidence to harm him. It goes without saying that all materials and information in the Commonwealth's possession, custody, and control regarding the prosecution's relationship with Ms. Peter, including evidence she provided to the Commonwealth in its investigations of Mr. Kearney, is critical to its defense and must be disclosed pursuant to Brady versus Maryland and other Supreme Court, both federal and Massachusetts precedent, as well as Rule 14 of the Massachusetts Rules of Criminal Procedure. The July 7th, 2025 production was inadequate. Our recognition of the obvious discovery issues associated with the Commonwealth's substantial reliance on Mrs. Peters resulted in 4 defense demands for discoverable and exculpatory materials related to Ms. Peter beginning on October 8th of 2024. Until July 7th, 2025, each of these specific and detailed demands was met. with a shrug of the shoulders and complete silence from the Commonwealth, as was a May 1st, 2025 court order compelling disclosure of any Peter-related discoverable materials to the defense by May 21st of 2025. Folks, this is material that under Brady versus Maryland, the Commonwealth is required as the prosecutor to turn over to a defendant. And the fact that they're not turning it over raises several questions. Let's just let Mr. Bederow roll on and tell us. We now know that most of the discoverable and specifically demanded information has been in the actual possession of both special prosecutors since at least December of 2024, when Mr. Mello emailed evidence of Ms. Peters' communications with himself and Lieutenant Brian Tully to you. Remember Lieutenant Tully from the Karen Reed case? Inexplicably, this critical evidence remained undisclosed for almost 7 months, even as demand after demand for it was made, and the court ordered its disclosure months ago. If this wasn't bad enough, on July 7th, 2025, the court and defense were led to believe that the July 7th, 2025 production contained more than 5,000 pages of discovery and included all of the Peter materials we have sought for almost a year. As it turns out, what we were told on July 7th, 2025 was inaccurate. What was represented to the court, in open court, folks, and to the defense was as 4,727 pages of relevant material from Lieutenant Tully's cell phone, in fact, contained more than 4,000 blank pages. Wait a minute. They said that they had 4,727 pages of relevant material and 4,000 of them were blank. Really? I mean, it's just beyond belief. This is just another few hundred pages of purportedly relevant materials were entirely redacted without explanation. Accordingly, we demand an immediate production of the entirety of the relevant materials from Lieutenant Tully's cell phone prior to August 13th, 2025. Ms. Peters' relevance to the investigation against Mr. Kearney. The materials disclosed on July 7th, 2025 demonstrate that in October of 2023, Ms. Peter began to communicate regularly with Mr. Mello, Lieutenant Tully, and Sergeant Yolie Medina. She gave Mr. Mello and the MSP information and numerous edited audio and video materials without providing a chain of custody or proof of its reliability. It appears that Mr. Mello simply accepted Ms. Peters' assistance and presented her unvetted evidence to the grand jury that indicted Mr. Kearney in December of 2023. 2 days before Mr. Mello commenced grand jury proceedings against Mr. Kearney on November 2023, Mr. Peter provided Mr. Mello with, it's all redacted. With this shocking level of access to and influence on Mr. Mello, it is not surprising that Ms. Peter later bragged to redacted about redacted, which included conversations with redacted about possible charges against Mr. Kearney. Evidence of possible leniency and consideration during the period in which Ms. Peter provided substantial assistance to the prosecution. She was a defendant in at least 2 criminal cases, one of which remained under the jurisdiction of the Norfolk DA for approximately 1 month. On November 16th, 2022, Ms. Peter was charged with violating a protective order in Suffolk County. That matter remained open until it resolved favorably for Ms. Peter on October 26, 2023. She's cooperating with the prosecutors in one county, and then she gets some favorable treatment in another county. On November 21st, 2023, Ms. Peter was charged in the Stoughton District Court with violating another protective order related to the same victim. This case remained under the jurisdiction of the Norfolk DA until December 12th, 2023, when it was determined that a special prosecutor was required due to the conflict of interest presented by Ms. Peters' prosecution by the same office to which she was providing assistance against Mr. Kearney. Indeed, on the same day, the Norfolk DA recused himself from Ms. Peters' Stoughton matter, redacted, joked to Ms. Peter that Mr. Kearney redacted. And then we're referred to the October 8th letter, which we've talked about before. This is crazy. Ms. Peters' communications with Mr. Mello, Lieutenant Tully, and Sergeant Buchanan reveal that she actively communicated with Norfolk DA prosecutors and investigators. At the same time, she was facing at least 2 criminal charges, and during the time she was being prosecuted by the Norfolk DA. It is inconceivable that Mr. Mello and the Mass State Police detectives were unaware of Ms. Peters' criminal history and the ethical and legal issues attendant to their regular communications with a criminal defendant represented by counsel. It would be inconceivable. What a coincidence. Nevertheless, Ms. Peter did communicate regularly with the authorities, and she and her boyfriend did receive favorable treatment in their criminal cases. Accordingly, we again demand all information, which tends to show that Ms. Peters sought, expected, and or received leniency and consideration in exchange for her assistance against Mr. Kearney, including but not limited to any documentation or record of communications with Ms. Peter or her attorneys with the Commonwealth about Ms. Peters and or her boyfriend's criminal cases. So we are going to take a quick break in just the outright reading of this, because I've got to point out that, one of the things relevant here is that this letter by Mark Bederow was posted, I assume by him or one of the members of his firm, in the docket. It was posted in the docket. That's what we do these days. We used to go to court and get a timestamp and put the documents in, or we would mail them in, and then the court would stamp the dockets, and it would go in the docket. Now we do it all electronically. And this letter that I'm reading to you was in the record of the court case with a number, but it has been removed. At first, there was a note that had been scribbled by the court clerk that said in the docket that this correspondence is not proper. This should be refiled as a discovery document. This is not a proper discovery document. So what's going to have to be done? I mean, the prosecutor is on notice that there's a request, but the defense attorneys for Aiden Kearney are going to have to recast this. And I think the deadline's probably gone, but which is why it might be in the form of a letter, but they're going to have to recast this as a supplemental request for documents pursuant to the criminal rules. And they'll just have to, the request that I just read, so we hereby demand, that'll just have to be enumerated as a request 1, request 2, request 3. So it's probably something that a legal assistant would be able to do fairly quickly. But it is something that's going to have to be done. So we go back to the letter. Ms. Peters' falsification of evidence to harm Mr. Kearney. The Commonwealth has not provided us with documents, videos, recordings, files, and other information that Ms. Peter provided to Mr. Mello and the Mass State Police. Her emails with Mr. Mello and Lieutenant Tully reveal that she repeatedly redacted that Mr. Mello later used to seek Mr. Kearney's indictment for wiretapping Ms. Gaetani. Ms. Peter failed to demonstrate the reliability of redacted or to reveal an adequate chain of custody to confirm its authenticity. Obtaining exact and accurate copies of evidence that Ms. Peter provided to the Commonwealth is particularly important given her penchant to falsify evidence to harm Mr. Kearney. In March of 2020, we're going way back. I mean, that's the month that the pandemic pretty much shut everything down, just to put perspective on all of this. Way back then, Ms. Peter and Mr. Kearney were embroiled in a YouTube copyright dispute. Aha, here's the motive. They were embroiled in a YouTube copyright dispute over ownership of online content. As part of this minor spat, Ms. Peter e-filed YouTube in California a document which she represented was a federal copyright civil complaint she filed in the non-existent case of Catherine Peter versus Aiden Kearney, Worcester Digital Marketing LLC. That's his business. Ms. Peter electronically signed the filed complaint. After Ms. Peter transmitted the document from Massachusetts to California, YouTube ruled in her favor and struck Mr. Kearney's content. So the whole thing was phony. She phonied up a federal complaint that she allegedly, purportedly had filed, which she had not. And it's just, what can I say? Attorney Bederow said it better than I ever could. Ms. Peters' complaint was in fact a forgery, and her lawsuit fabricated out of whole cloth. She located an authentic copyright claim filed in the District of Massachusetts in 2013, Exhibit C, and then brazenly changed the caption and other information in the authentic document so that her forged document appeared to be an actual civil complaint she filed against Mr. Kearney. Oh, come on. She didn't think that she would be caught. I mean, all this stuff is electronic. Anybody can go on the federal PACER system and take a look and see, if something that is purported to be a document that's been filed, if it's a real document. Anybody can. You need an account with PACER, but all you need to get an account with PACER is a credit card or an office account or a debit card or something, but you need some way that they can charge you 10 cents a page. She signed the falsified complaint, represented it to be a true and accurate civil complaint, and transmitted it in interstate commerce in furtherance of her fraudulent and criminal scheme to intentionally mislead YouTube into ruling in her favor, which based upon her forged documents they did. It's not funny. I almost laughed. It's not funny. It's not funny at all. It's ridiculous. A few years later, Ms. Peter admitted during an online interview that she submitted the forged complaint with the intent to defraud YouTube because of her hatred for Mr. Kearney. And there's a link that you can confirm everything. I mean, again, all this stuff is confirmable electronically. She rationalized her crime. Everybody has a reason. Everybody has an excuse. Well, I was bad, but here's why. She rationalized her crime and defended her credibility by reasoning that she was now trustworthy because she admitted I committed the crime, so now I'm trustworthy. Yeah. Were you telling the truth then, or were you telling the truth now? Notably, given the 6-year statute of limitation, Ms. Peter remains subject to prosecution for forgery in Massachusetts until March 24th, 2026, as I sit here today. That's sometime for her criminal conduct. And Mr. Bederow cites the various rules and statutes. The case with Ms. Peter was willing to forge and falsify documents to injure Mr. Kearney is significant here for two reasons. First, Ms. Peter's personal bias against Mr. Kearney and her pattern of fraudulent and criminal activity makes Mr. Mellow's willingness to delegate investigative work to her and then rely on her evidence an additional basis to warrant his removal from the prosecution team, because these circumstances increase the likelihood that he will be a defense witness. Second, Ms. Peters' bizarre role as the primary source of the evidence against Mr. Kearney, notwithstanding her history of documenting evidence to further her own interests, is further complicated by the Commonwealth's failure to provide the defense with discoverable evidence related to Ms. Peter that unquestionably has been in the Commonwealth's possession, custody, and control for years. I mean, I don't see why there's not a successful motion to dismiss the entire case against Kearney. I mean, this is outrageous, regardless of how you feel about him, his conduct, whatever. This activity is just outrageous. I think any resident of the Commonwealth should just be shaking their heads about this. Undisclosed evidence provided to the Commonwealth by Ms. Peter. A survey of the communications between and among Ms. Peter, Mr. Mello, Lieutenant Tully, Lieutenant Fanning, and Sergeant Buchanan demonstrates that the prosecution has not disclosed a plethora of materials, a lot of stuff, folks, and information in its possession, custody, and control, including those described below. On October 3rd, 2023, days before Mr. Kearney's arrest, Lieutenant Tully emailed Lieutenant Fanning, Sergeant Buchanan, and former trooper Michael Proctor that redacted. Demand is made for the immediate production of all redacted regarding Ms. Peter, as well as and any other materials or information referenced in the October 3rd, 2023 email chain between Lieutenant Tully, Lieutenant Fanning, Sergeant Buchanan, and Mr. Proctor. This stuff is hard to read, folks, because there's so many redactions. You can't stay in the flow of the document. What Mr. Bederow is saying is fairly obvious. These people were, collaborating with this woman and of questionable motives. She had criminal matters pending that she wanted favorable treatment on, and who just is not, according to any of this, a relevant, credible person. I mean, she's phoning up federal documents. And so it's just it's hard not only to read, it's hard to comprehend that people have this much animus against someone else. It's hard to comprehend. So going back to October 25th of 2023, Ms. Peter emailed Lieutenant Tully that she and her team, whatever that means, redacted. So maybe they explain who's on this team and they have to be protected. I don't know. Demand is made for production of the exact redacted and redacted. Ms. Peter provided to Lieutenant Tully on October 25th, 2023. So obviously what Turtleboy's defense needs is all the documents that were turned on. What was said by her to these police officers who, have a bad, horrible record. I mean, Proctor was dishonorably discharged, and the others, Buchanan was removed from his duty and sent to an administrative job. So what was going on between them all? What was said? What documents? What emails? What telephone conversations? It all has to be turned over if the Commonwealth is going to maintain, the fact that they can do a straight prosecution. I don't think they can. On November 1st of 2023, Ms. Peter emailed Lieutenant Tully, redacted. Demand is made for a copy of each version of this redacted file and any redacted. I don't know. It would seem to me some of the stuff that's redacted, I don't know. Obviously they're going after emails and maybe texts, and maybe they used social media, whatever. It should all just be turned over. But they're looking for copies of everything that was made by Ms. Peter as described in her November 1st, 2023 email to Lieutenant Tully. On November 17th, 2023, Ms. Peter emailed Lieutenant Tully. Demand is made for the redacted provided by Ms. Peter to Lieutenant Tully on November 17th, 2023. And my apologies for laughing. It's unbelievable. The circumstances here are unbelievable. And it's on November 26, 2023, 2 days before Mr. Mello commenced grand jury proceedings against Mr. Kearney, Ms. Peters emailed to Mr. Mello, redacted. On information and belief, Mr. Mello used this information, I would imagine, during the grand jury presentation. Demand is made for a copy of these redacted, any redacted, and any records of phone, text, email, or other communications between Ms. Peter and Mr. Mello. All information regarding how any redacted were redacted, when they were redacted, by whom they were redacted, and all documentation or information regarding Mr. Mello's reliance on Ms. Peter as a source of information as described in their November 26, 2023 correspondence. So again, it's hard to keep the flow when so much is redacted, but we get the point. They want everything that went on between the prosecutors, the state police, and the source, and they have a right to it under Brady v. Maryland and other precedent by the United States Supreme Court, as articulated also by the Massachusetts Supreme Judicial Court, and they have a right to it. On December 20th, 2023, Ms. Peter emailed Mr. Mello and Lieutenant Tully about some circumstances that are now redacted. Demand is made for all items provided by Ms. Peter to Mr. Mello and Lieutenant Tully on December 20th, 2023, including any information given to Ms. Peter by whoever, might have been Proctor, might have been, a now secret informant. On December 28th, 2023, Ms. Peter emailed Mr. Mello and Lieutenant Tully material. Demand is made for any notes or documentation regarding the conversation between Ms. Peter, Mr. Mello, and Lieutenant Tully on December 27th, 2023. And there's more redactions. January 3rd, 2024, Ms. Peter emailed Mr. Mello. Demand is made for the names of the 27 people referenced by Ms. Peter and any information they provided, and for a copy of the whatever, probably information provided by Ms. Peter to Mr. Mello on January 3rd of 2024. Now we go again to January 3rd of 2024. Ms. Peter emails Mr. Mello and Lieutenant Tully again. January 25th, Ms. Peter emailed to Mr. Mello and Lieutenant Tully. I'm going to skip over some of this because they're documenting dates that there were communications between Ms. Peter and the various law enforcement, Lieutenant Tully, Sergeant Buchanan. I'm going to skip some of this. Look how much of it, has been redacted. But here we get to the point of it all, the conclusion and the point of it all. It is obvious that the Commonwealth relied on Ms. Peter to build its cases against Mr. Kearney at a time that Ms. Peter was a criminal defendant. Remarkably, the Commonwealth farmed out the investigation to Ms. Peter despite her well-known hatred for Mr. Kearney, which is so intense that she foolishly filed forged federal court documents to gain an advantage over him in a civil matter. It is also clear that Mr. Mello's relationship with Ms. Peter, as evidenced by his own communications with her, his reliance on her unvetted evidence, as well as Ms. Peter's claims about her private access to him and his willingness to engage in conversations with her about Mr. Kearney, further warrants his immediate removal from the prosecution team because he is a material fact witness. This is unbelievable that this kind of thing happens. What an unseemly relationship that's developing between a criminal defendant and the top prosecutors. And I mean, it's not unusual. I mean, there are confidential informants. We all know that. And they have, been the basis for a lot of information that's handed over to prosecution over the years. But this goes over the edge. I think any objective observer would have to agree. If you don't agree, let me know down in the comment section. Let me know down in the comment section if you disagree. For these reasons, we request a prompt response to the above cited issues, and we demand full compliance with Rule 14A2, that's a discovery rule, and B2A, which require you at a minimum to inform the prosecution team about their possible possession of discoverable evidence, and if any exists, to collect and then disclose any such evidence, irrespective of whether you credit it. Respectively, Mark Bederow, with copies to Timothy Bradel, Ken Mello, the clerk of court at Norfolk Superior Court, and Aiden Kearney. And this was docketed earlier. This was docketed in the Norfolk County Superior Court docket for this case, and it's disappeared. There was a note that was said, this is inappropriate. This would need to be filed as a discovery motion. And then that note disappeared. At least the last time that I went on to the docket, right before I'm recording this episode, it had been removed. So the individuals include, but are not limited to, Mr. Mello, Mr. Lally, Laura McLaughlin, Hank Brennan, Lieutenant Fanning, Lieutenant Tully, Sergeant Buchanan, Mr. Proctor, Stephen Nelson, and any other victim witness advocates. So it's eye-opening, jaw-dropping, and that, folks, is the Bederow letter. That is the Bederow letter, and it is really something else to take a look at. It's just really hard to believe that it has gotten to this point. There will be a hearing in August, I believe on the 13th, a status hearing to look at the compliance with respect to discovery. And compliance is very important in a criminal case because a defendant has a right to know what underlies the charges against them, especially if some of the stuff has been phonied up, as appears in this case. So we just mentioned in the footnotes Special Prosecutor Hank Brennan. So now we are going to take a look at his bill for $566,000. So the way we're going to take a look at this, and the entire bill of Mr. Brennan was referred to in a column by none other than Howie Carr in the Boston Herald. Now, I've known people that worked with Howie, and I've known people that back when Howie was in the TV business, he would get comments by people driving around Boston. And one of the reasons he would get comments is because he wrote excellent articles like this. Karen Reed prosecutor Hank Brennan took in $566,000 for his work. See the invoices. Hank Brennan earned $566,000 for his work as a special prosecutor in the second Karen Reed murder trial records show. I think all of my viewers know that the first Karen Reed trial in 2024 was prosecuted by Adam Lally. I guess the DA said, let's try a different approach. Let's bring in somebody else. And so they hired Boston attorney Howard Brennan, Hank Brennan. He was brought in and he was called special prosecutor. His initial bill called for him to be paid at a rate of $250 an hour, which is very reasonable for a Boston attorney who is experienced. And you got to give him that. He is experienced. And it was to be capped at $75,000. Well, that contract apparently was amended, we'll say, 3 times. And I guess they were hoping that it would be out of the light of day, but it was not. Brennan, a longtime defense attorney famous for representing Southie mobster James Whitey Bulger in his federal trial, was hired by Norfolk District Attorney Michael Morrissey to lead the prosecution in Reed's second trial on charges including second-degree murder in the January 29th, 2022 death of Boston police officer John O'Keefe, her boyfriend at the time. So when Brennan represented Whitey in that trial, his co-counsel was a guy by the name of J.W. Kearney, who was one of my advisors in Suffolk Law School when I was in the moot court board. I doubt if he remembers me because it was many years ago for both of us, but J.W. Kearney and Hank Brennan defended Whitey. And, I don't know why anybody would defend the guy anyhow, but the thrust of that trial was really, look what the federal government has done. Look how they just kind of coddled Whitey all these years and let him get away with the things that he got away with. And then a tip was given to Whitey to get out of town, and he was on the lam for 18 years. But I digress from this particular article, which goes on to point out that the Karen Reed second trial ended last month with Reed's acquittal on her indicted charges of second-degree murder, manslaughter while operating a motor vehicle under the influence of liquor, and leaving the scene of an accident resulting in death. Jurors did convict her of a much lesser charge of drunken driving, also called operating under the influence, or OUI. It turned out to be the most expensive OUI trial in history, Reed defense attorney David Yannetti told the Herald in an interview shortly after the trial ended. And that's true. Earlier in my career, I did do a fair amount of OUI and DWI. First time I stepped foot into a New Hampshire court, they said, "Man, you're from Massachusetts, aren't you? Because you called it OUI." Well, that's what the statute calls it in Massachusetts. And by the way, I've lived in New Hampshire on and off for 50 years. So I didn't take kindly to the court people saying, "You're not from here, are you?" Anyhow, I digress again. Through his law firm, Brennan and Associates, Brennan submitted 7 invoices covering his work from September 17th, 2024 through the trial's end on June 18th of 2025. The invoices total $566,000 for 2,264 billable hours. Oh my God, that's a lot. That's a lot. Brennan was officially appointed as a special assistant district attorney for the Reed case on September 23rd, 2024, according to the contract inked that day by Brennan and Norfolk First Assistant District Attorney Margaret Krippendorf. That agreement set his hourly rate at $250 and had capped compensation at $75,000, a figure that Brennan blew past by more than $45,000 in his second invoice. The invoices were released as part of the Norfolk DA's initial response to a public record request by the Herald. Assistant District Attorney Brandon Hunt, who is in charge of such requests, says that more data will be delivered on a rolling basis. Okay. The Brennan invoices break down this way. First invoice, September 17th to October 31st, 2024, 283 hours totaling $70,000. So in the first month, he was already up to $70,000, almost peaking out at the 75. Not quite. But wait, there's more. The second invoice on November 24 was for 201 hours, totaling $50,000, 325. So before Thanksgiving, that $75,000 cap had been blown past. You're shopping for your turkey. Boy, Brennan had enough money for a lot of turkeys and caviar and God knows what else. Third invoice, December 1st to December 29th, 2024, 210 hours, $52,000. Fourth invoice, December 30th to January 10th, 121 hours, totaling $30,000. That was a light month. We're out shoveling snow and looking at the bills from the holiday, so it was down a little bit. Fifth invoice, January 11th to January 25th, 2025, 114 hours, totaling $28,675. Sixth invoice, January 26th to March 31st of 2025, 653 hours, totaling $163,375. The seventh invoice from April 1st to June 18th of 2025, 678 hours, totaling $169,500. So that's the big bill. That was for the trial between April 1st. The trial started in mid-April and ended on June 18th. That was the day that the final verdict came out. So to try the case between April 1 and June 18th of 2025, 678 hours, totaling $169,000. So that's the general bottom line of the bills. But there is more. We're not going to read every single item. I promise you, we're not going to bore you with every single item. But on September 17th of 2024, Mr. Brennan, as special prosecutor, billed for 6.5 hours. See that number over there? Phone conference, watch trial openings and closings, review court orders, legal research. Now, I don't know if you remember the very first hearing in late September of 2025, where Mr. Brennan was excoriated because he went before the court. He said, "Your Honor, I haven't fully reviewed the trial yet." Well, this bill shows that he did get around to doing it. So let's jump to September 19th. 8 hours, trial review and discovery plan, research case, update agenda, review search warrants, conference call. And then look at 9/20, September 20th of 2024, 10 hours, 10-hour day. So like if you start at 9 o'clock in the morning, and I don't know if you can start at 9 o'clock in the morning because he lives out in the burbs. And to get into Boston, I don't care whether you're driving, taking the train, taking the T, because I used to do all of those things. It takes forever. But on September 20th of 2024, he watched trial testimony, prepared for meeting, reviewed documents and meeting, conference call, identified evidentiary issues. Okay, so please don't give me a hard time down in the comments. Okay, give me a hard time down in the comments. He did, even though he said in open court that he hadn't reviewed the trial yet. Here he is, reviewing. So now we're going to jump down to September 25th. Review witness statements, review the reports and photos, research of the reports, conference calls, 5 hours. So he had a short day that day. We go on and on and on. He looks at the discovery, case strategy, only 6 hours for case strategy on October 3rd, October 4th. Meeting regarding motions and discovery, strategy meeting, discovery meeting with paralegal, phone conferences, research. So he mentions the paralegal, but meeting regarding motions and discovery. Who is he meeting with? Alan Lally Is he meeting with District Attorney Michael Morrissey? Who is he meeting with? Then on October 5th, he's reviewing forensics, conference with paralegal. So when he's talking with his paralegal, as long as it's about this case, he's billing $250 an hour. Not bad, especially if you're allowed to go down to Legal Seafood and do it over there. Discovery disclosure, discovery review meeting. Here we go on October 11th. Meeting, prepare motion filing, legal research and motion drafting. Now, again, excoriate me down in the comment section, but it does take time to do research for a motion. You might have learned it all. You might have done it all. You might have done another motion in a similar case a year before, but the law evolves. There are new cases. The Supreme Judicial Court of Massachusetts is a busy court, and they are reviewing things that come before them all the time. So it goes on, 9-hour day in October. We go through October. He's reviewing everything, getting ready. If you'll recall, there were a lot of motions. There were a lot of motions that were being filed. So here we have November, preparing for court hearing. Like I just said, there are motions that are coming up. Remember back in December of 2024 and January of 2025, he was given the advantage of voir dire hearings, 2 of them with the dog bite expert. And he, here he is preparing 4 hours one day, 12 hours the next day, 13 hours the next day, so spent a lot of time, trying to get that dog bite expert disqualified, and didn't work. So there's that bill. He does them every month. He submits these bills every month. Let's see how much he worked in December, Christmas. A lot of us are busy shopping, planning, doing all that good stuff, going to Christmas events, I'll say. Holiday events, I suppose I should say. Here we go with the Lanigan hearings. Case preparation. Dr. Russell, I'm sure that's what that's all about. He really tried to nail her. Didn't work. She was an excellent, incredible witness. Look at this. Christmas Eve, 12/24/24, reviewing witness testimony, 6.5 hours. 6.5 hours on Christmas Eve. Then Christmas Day, December 25th of 2024. Mr. Brennan puts in for drafting motions, review past filings. 2 hours. Now, I know he has kids, so come on. Really? Come on. He worked 2 hours on Christmas Day? So then, I guess the last bill we have for 2024, he didn't work on New Year's Eve, which would have been December 31st. So we don't have a bill for that because I believe this is the end. But December of 2024, a $52,000 bill. How many people in my audience, please let me know down below, how many people in my audience were paid $52,000 just for the month of December? I don't see any hands going up. Okay, so no bill for there's no bill as far as I can see for New Year's Eve. Oh, I was wrong. There we go. Look at it. So he puts that on the January bill. I stand corrected. So New Year's Eve, December 31st, 2024. Always prepare for these things. Always pre-read your copy. I was taught that way back in broadcasting school at Emerson College, many more years ago than I want to admit. Always pre-read your copy. December 31st, New Year's Eve, expert meeting, administrative matters. Who's doing administrative matters on New Year's Eve? Come on now. Going out to the store and buying some adult beverages. Strike that, edit that out. Review statements. So New Year's Eve, 3.9 hours at 4 hours. Then New Year's Day. I usually am taking down the Christmas tree and watching the parades and stuff on TV. He was working 12 hours on New Year's Day. He was working 12 hours on New Year's Day this year. Tell me down below, do you believe that? Do you believe that? I don't remember the weather. I don't think it was snowing. I think it was cold, but I don't think it was snowing. Oh, boy. I guess if you have a big trial, I mean, I have been known to work a few holidays, but I mean, oh, my goodness. So this goes on and on. We're not going to, like I said before, we're not going to go on. We're not going to go through all of it. You can get it on the Boston Herald's website. I do subscribe, but I think you can subscribe for short money if you're a non-subscriber and have a subscription for a year. And so this is just the paperwork. This is just the paperwork that attends anytime you have a contract with the state. And we're not going to dox people to the extent that we give, all the inside information on the thing. But, that's quite a bill. Wouldn't you agree that that's quite a bill? And guess who the bill was sent to? The taxpayers of Massachusetts. All right, the bill was sent to the Norfolk County District Attorney, and the Norfolk County District Attorney's office paid the bill, but we all know who the real people were that paid that bill, and that's the taxpayers of Massachusetts. And a lot has been said about, they had a ton of attorneys in the Massachusetts District Attorney's office, the Norfolk County District Attorney's office. They had a ton of attorneys in that office, and according to Vanity Fair, when they came out with an article on why he was hired, apparently none of the top prosecutors in the Norfolk County District Attorney's office would try the case. They all refused to try the case. And I called down to the Norfolk County District Attorney's office, Michael Morrissey's office, and I actually spoke to a press person there way back. I forget whether it was October 30th or October 31st of 2024. And I actually talked to a human, and he said he couldn't comment on it. He referred me to a press release that had been issued in September of 2024. And I looked at it. It was on something totally unrelated to this case. It was on a car accident or something like that. And so I was yesed off the phone by the press person at the district attorney's office. So I wrote him a letter and I faxed it to them. I'm not going to dox them now, but if you go into the Norfolk County District Attorney's website, there is a fax number. So I faxed them a letter. I said, I just couldn't believe this. I could not believe that the top prosecutors in the Norfolk County District Attorney's office all refused to try the case. I said, please confirm or deny and get back to me. I understand that you're busy. I understand that there are constraints against speaking, although Michael Morrissey did put out a statement about this case on video. And also Michael Morrissey had just previously hired a press guy from the newspaper industry who was getting a six-figure salary. So why couldn't he get back to me with a fax? How long does it take to bang out a fax and send it out? Don't even have to spend, what is it now? 75 cents for a first-class stamp. Ghosted me. I contacted him one other time ago. So my direct requests to Michael Morrissey, the district attorney in Norfolk County, have been ghosted. No comment. So I can only assume that it's true what Vanity Fair article printed some time ago, that none of the top attorneys at the Norfolk County District Attorney's Office would try this case. And so that's why they had to go outside and hire Special Attorney Howard Brennan, and at first promised, well, we're going to cap it at $75,000. But now, as we just saw the itemizations, working Christmas and New Year's Day, the total bill, $566,000. And I asked someone very recently in this office, how would you like to work for half a year and make over $500,000? Yes, I'll do anything. So anything legal. So there we have, in this episode, we have the most recent Bederow letter, and that's been stricken from the docket in Norfolk County Superior Court. And there we have the invoices from Mr. Brennan. I know this goes back about a week. It's old news, but it is summer. Things are a little bit slow. I know in the beginning of the episode I said things are not slow this week, but commenters have had things to say about this. And goodbye, Mr. Brennan. Hello, commenters. What do you have to say to me this week? Let's go down into the comments section. Number 5, Diane Gallagher. Diane says, love your coverage. I suggest you look into the crazy past of both Brian Walsh and his real estate wife. That would be Anna. And this comment goes back to an episode we did a week ago where we covered some of the occurrences in the Walsh case. And she says, look into this crazy past of both Brian Walsh and his real estate wife. There are definitely wild side stories leading up to her disappearing, including why he was on an ankle monitor for his federal case of the sale of a fake Andy Warhol painting. That's true. And we did an episode on this way back in early 2023. Anna Walsh, of course, disappeared New Year's Eve, 2023, 2024. And we did do an episode on that. And we did mention that he was under, federal conviction awaiting sentencing for selling a fraudulent painting. He sold a Andy Warhol painting for a ton of money, and it turned out to be a fake. So we'll get into it. We're going to get into it again because the trial's coming up in October of 2025. Number 4. It will get worse, and the proverbial bar and expectations for Norfolk County is already so low. That's true. Now we have Rock and Rolla 2023. The same deleted people. We don't like it when you call names. I often stop reading your comments if you call names. But I did think that we should put this comment in our episode. The same deleted from the Reed case. Surprise, surprise. This is getting ridiculous. They just feel like they can do anything they want because they say so. And it's that whole cast of characters we read about in the Bederow letter earlier in this episode. Tully and Proctor and Buchanan and all the others. Number 2, Linda Horton. In my limited observation, if the evidence makes it obvious that the accused is guilty, the judge lets the evidence in anyway. It's not supposed to be that way. Without a warrant. In Karen Reed's case, all that taillight evidence came in from an unsecured crime scene. The judge let it in anyway. Other cases, other judges have made similar decisions. No body makes it difficult, but no impossible. Yeah, nobody makes it difficult, but remember that they had all of those searches, how long for a body to start to smell? Can you make the smell go away with baking soda? How long after someone disappears to inherit? I mean, just to name a few. Number 1, Pam Tripley. They really are incompetent, aren't they? No comment. Watching from Australia. Thank you. We get a lot of people from Australia and New Zealand. Thank you. We get a lot of people from that part of the world. It's a primarily English-speaking area, and we thank them very much. We want you to let us know where you are coming from. I promised to retire this slide, but I changed my mind. We have had comments largely from the Karen Reed case, but we're going to expand this to anyone that's watching any of our episodes, like this one. We have received comments and questions from people in 75 countries around the world, and there they are. They're all listed. Take a look at this. If I move on too quickly, come back, pause. Take a look. If you're calling us, if you're watching us from any of the countries that are not on this list, let us know. I'm not going to read them all from Albania to Zimbabwe. We have 75 countries that have had people contact us, and notably China, several people from China. And I thought that they had blocks on their internet access in China. But I guess depending on where you are and who you are, it's okay for you to have certain internet access. So if you're from a place that is not on the list, let us know. And with that, that's pretty much it for this episode. I'm sorry I've been reading so much, but it was good stuff. I thought it was pretty good stuff in this episode. And if you have any ideas for future episodes, now that the Karen Reed trial has wound down, we do have the Aiden Kearney trial coming up, and we also have the matter of Brian and Anna Walsh. We have our eyes on some other cases. Sarah Boone is complaining that her attorney's not calling her back, her appellate attorney. So please, let us know. If there are other episodes, if there are other cases you want us to follow, let us know, because I'm open to suggestions, whatever you would like us to cover. A lot of stuff going on in the world. I'm open to other things that are going on in the world besides just true crime. There are a lot of things happening in the world that, are interesting. That air crash in India was just, one of my favorite TV shows is Air Disasters, only because I don't like plane crashes. Of course not. But just the way investigators, look at every single piece of wreckage, and they get the black boxes, which aren't black, they're orange, the cockpit voice recorder and the flight data recorder, and they put it all together. And that crash apparently occurred after the fuel switches were turned off. And so let us know down below what you would like to have us tell you about. And so that's it for this episode. And if you have watched all the way to the end here, thank you so much. I really appreciate it. Subscribe. Our goal is 100,000 subscribers by the end of this year. It's a tough goal, I know, but we're going to do what we can. Tomorrow, the day after I'm recording this episode, I am going to be attending the True Crime Podcasters Festival in Boston. It's actually in Danvers, but those of you who are outside 495 and outside of Massachusetts, Danvers is close enough to Boston. So hopefully I'll be bringing back some information about that. And if you've watched this far, I would ask you to give us an emoji of a snowflake. Give us a snowflake emoji. And until then, I want to thank you. Enjoy the rest of your summer. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.